Well, a great deal of farm personal property is out in the open, and often the equipment and grazing livestock sit outside, all of which raises concern about public access to the premises. But does the posting of that property as no trespassing have any actual legal consequence? Well, joining us now is Roger McEowen. He's with the Washburn University School of Law. Roger, as always, thanks for sharing your knowledge with us. What are the benefits of posting property with those signs?
Well, good morning, Janet. Good to be with you. And there are some benefits, and the benefits do vary from state to state because the states set various rules, and the various departments of wildlife or Department of State Parks, whatever it's called, also have their regulations too. But one of the potential benefits of posting your property as no trespassing is that it might cause, depending on the state you're in, what is otherwise a civil trespass case, which would be one neighbor against another neighbor, or the landowner suing the trespasser for any civil trespass. It might convert it into a criminal trespass, and that gets the state involved in actually prosecuting the trespasser. And that might be viewed as having a greater disincentive for people to trespass than would a civil trespass, because the civil trespass, as I indicated, is just prosecuted by the landowner personally against that alleged trespasser.
And what about search warrants? How are those impacted by posting with those no trespassing signs?
Yeah, this is one issue that we don't really think about too much, but another possible benefit of posting your property as no trespassing is that it might cause a search warrant to have to be obtained before your property can be searched for potential criminal conduct. That's because under the Fourth Amendment to the Constitution, unreasonable searches and seizures are prohibited absent a search warrant that is judicially approved and supported by probable cause. So by posting your property as no trespassing, that says that, look, I've got a real privacy expectation here. I'm letting the world know that I've got a privacy expectation. And so if you think there's criminal conduct going on here, because that privacy expectation is very real due to my posting, you've got to go get a search warrant first.
Do you have any examples, Roger?
Yeah, indeed. In a recent case out of the Supreme Court in the state of Vermont, a fish and game warden entered the defendant's property through a neighbor's adjoining property, and he found a blind with a salt block and apples nearby. And there was a rather precarious path through tough timber that was used by the warden to avoid detection. Well, the landowner got charged with baiting and taking big game by illegal means, and at trial, he testified, look, I had my property no trespassing all over the place, and I had keep out signs all around the property, as well as on the gate to the public road, which was gated off. And the warden said, well, I didn't see any of the signs. And the landowner motioned to exclude the evidence that the game warden obtained because he never got a search warrant. And he said, I've got a reasonable expectation of privacy because I posted my property. And the court agreed. And that evidence all got tossed out.
Very interesting. Well, Roger, as always, thanks for taking the time to chat with us. Roger McEowen, he's with the Washburn University School of Law, on the phone with us today from Topeka, Kansas. You can go online to washburn.law.edu for additional information.